Shalva's Domestic Violence Awareness Month continuing legal education program on the Jewish divorce process and get refusal. My name is Vicki Rifkin. I am the Outreach and Education Legal Liaison for Shalva. Our Legal Liaison program has two components to it. One is that we have an in-house attorney that works with our clients and helps them understand the legal system and does a lot of education and represents a limited number of clients in their cases. I, as the outreach person, do programming like this to educate attorneys about the intersection of domestic violence and the law. I also recruit attorneys to represent our clients on either a full fee, a sliding fee, or pro bono, depending on the client's financial situation. So if that's something that you'd be interested in doing, certainly let me know. My email is vrivkin@shalvacares.org. I will put that in the chat as soon as I'm done. A couple other housekeeping matters. We are only using the chat function. So, someone already put a question in the question and answer. I'll try to get to those, but try and keep your questions in the chat box since I'm the one monitoring today. CLE certificates will be sent a couple days after the program. And anyone who doesn't know, Shalva is the domestic violence counseling agency for the Jewish community here in Chicago. Our mission is to support survivors of domestic abuse through counseling, supportive services, and community education. If you want to learn more about us, you can always visit our website or give us a call. And with that, I think I would like to start by introducing Rabbi Reese. So, Rabbi Yona Reiss is a noted Torah scholar, attorney, and jurist, is the Av Bet Din of the Chicago Rabbinical Council and a Rosh Yeshiva at the Rabbi Isaac Elchanan Theological Seminary at Yeshiva University, where he serves as the Rabbi L Katz Chair in Professional Rabbinics. That means he's really smart and everybody knows it. He's also a Haver Bet Din of the Bet Din of America in New York. He previously served as the Max and Marion Grill Dean of RIETS, which is the Yeshiva. Rabbi Reese is a summa cum laude graduate of Yeshiva College and a graduate of Yale Law School, where he also served as a senior editor of the Yale Law Journal. He received rabbinic ordination from RIETS, where he also earned the distinction of the advanced rabbinic degree of Yadin Yadin. From 1998 to 2008, Rabbi Reese served as the director of the Beit Din of America. In his directorship of the Beit Din, Rabbi Reese worked to resolve cases of agunot, including the 9/11 agunah cases, and popularized the use of the Rabbinical Council of America Prenuptial Agreement as a protection against future agunah problems. He's going to be talking about that a lot today. Rabbi Reese serves on the editorial board of Tradition Magazine, a frequent writer on a variety of topics related to both Jewish and secular law. He has published widely in Jewish and Torah publications, including the Journal of Halakha and Contemporary Society, Shara Tzedek, Beit Yitzhak, Kol Ziv, Kavod, as well as the Wall Street Journal and New York Law Journal. Most recently, Rabbi Reese published the book Kanfei Yona, a Hebrew language compendium of essays and responsa about contemporary issues of Jewish law and Talmudic topics. The books received approbations from leading rabbinic authorities throughout the world, including the two current chief rabbis of Israel. So all that is to say that we are so thankful to have Rabbi Reese here today. He is a special friend of Shalva. He has worked with our rabbinic task force and has helped out many of our clients who've needed the spiritual counseling and guidance that only a rabbi can provide. So with that, I'm going to hide myself and turn it over to Rabbi Reese.
Okay, great. Thank you. Thank you very much, Vicki. I really appreciate the kind introduction. I didn't even realize that my bio was so long. I apologize for that. But hopefully we'll still have a little bit of time left to discuss the issues. So the title of today's talk is The Get Process and Domestic Abuse And I consider myself somewhat of an expert, or at least an experienced practitioner in terms of the get process, not so much with respect to domestic abuse, where I have had the privilege of working closely with Shalva in terms of dealing with some of the thorny issues in that regard. And obviously there's an overlap, because as some individuals have publicized in recent years, there is a notion of domestic abuse that is attached to get refusal. First, one has to understand what a get is all about, to appreciate the notion of get refusal. But I don't think that it is such a stretch or such an outlandish proposition to maintain that get refusal is certainly some type of form of domestic abuse, to refuse to provide a spouse with the benefit of a Jewish divorce when a marriage is irretrievably over and the parties have no further marital relationship with each other, is certainly a sadistic act, preventing the other party from being able to go on with their life and essentially holding them hostage. So what is the get process? First of all, just in kind of simple terms, to give you a thumbnail sketch of what a get looks like, there is a biblical passage in Deuteronomy that says that if a couple is married and for whatever reason the marriage breaks down, then the husband has to hand his wife a get, a Jewish bill of divorce, in order for the husband and the wife both to be divorced according to Jewish law. The same way that according to biblical law, it is the man who provides the ring or object of value to the wife in order to consecrate the marriage in the first place. It's the man who delivers the bill of divorce in order to end the marriage. However, the divorce process is also one that, according to rabbinic law, has to be accepted by the wife voluntarily. Under biblical law, a man has to divorce of his own free will. Otherwise, it's not going to be a valid Jewish bill of divorce. He has to authorize the scribe to write the Jewish bill of divorce, authorize two witnesses to sign the bill of divorce, and then he has to hand over the Jewish bill of divorce, the document himself, to his wife's hands, or he can appoint an agent, a shliach, to deliver the get into his wife's hands. But the first question that we ask at any single get proceeding is, are you giving the get? Are you giving this, the get is the Hebrew word for the Jewish bill of divorce. Are you giving this of your own free will? And if the man says no, so then we have a problem because the requirement of Jewish law is that it be of his own free will. Under biblical law, a woman technically could have been divorced against her will. In fact, that was the reason for the enactment of the ketubah. The ketubah, according to Talmudic law, is there in order to prevent a husband from precipitously and impetuously divorcing his wife when the marriage can still be viable and when the wife still very much wants to remain in the marriage. So the ketubah contract actually requires the husband to pay a large sum of money upon the divorce of his wife, and the husband then might be deterred from divorcing his wife when the marriage could otherwise be saved, when he looks at the high price that it's going to cost him in terms of the ketubah amount. The ketubah really is a form of maintenance in the event that there is a divorce. So that would discourage and dissuade husbands from divorcing when the marriage really could be saved. However, by rabbinic law, there was a great rabbinic authority, Rabbeinu Gershom, who came along 1,000 years ago. He made the famous enactment that more people are familiar with, that a man can't get married to more than one wife. You might say that he's tired of one wife, so he doesn't have to divorce her, he'll just marry a second wife. So Rabbeinu Gershom said, no, just as a woman can't be married to two men under biblical law, so too under rabbinic law, a man can't be married to more than one wife. This cherem, this ban of Rabbeinu Gershom was accepted in the Ashkenazi communities, not completely in the Sephardic communities, but nowadays it's accepted pretty much all over that we do not allow a man to be married to multiple wives. But the other, lesser known enactment of Rabbeinu Gershom is that just as a man can only divorce of his own free will, so too a woman can only be divorced of her own free will, so that the Jewish divorce process must be a consensual process. Under Jewish law, if you do have a husband and a wife who both consent to get divorced, you don't need the approval, so to speak, of some papal authority. You don't need the official rabbinate of the country in which they live, or on an international level to approve or endorse the divorce. It's a right that they have under Jewish law, a biblical right, that a husband and wife, if they both agree between themselves that the marriage is irreconcilable and that they cannot remain in a viable relationship with each other, we don't hold people hostage. We don't force people to remain in a marriage against their will. That's all fine and good, of course, when it's consensual and both parties agree to the divorce. They set up an appointment here in Chicago. They set up an appointment with the Chicago Rabbinical Council, and we schedule a get. What does it mean to schedule a get? Very important that it be a process in which the parties feel comfortable and at ease. We all know how emotionally tense a divorce process can be. It's our goal and our intention to fulfill the Torah mandate of Derachea Darchei Noam, that the paths of the Torah are supposed to be pleasant. Shalom, all the ways and pathways of the Torah are supposed to lead to peace. So we try to do things very peacefully. If the parties are comfortable coming in together, we have a procedure. The whole thing lasts from 1 hour to 1.5 hours. We start off and we interview. There's a script, so nobody has to worry about what to say. It's all laid out in careful terms, very precise language. We ask the husband, are you giving the get of your own free will? The script says yes. Unless the answer is different, he could just read from the script. We have him nullify any vows or oaths that he may have taken, either to give a get or not to give a get, because if a person took a vow or an oath, that could compromise the volitional nature of the giving of the get. We then have the husband nullify any statements that he may have made, even if he doesn't remember, and probably never made any such statements, but any statements that he may have made that could harm the validity of the get. This is all to ensure that there not be any questions, because a get, the Jewish bill of divorce, is a very big deal. If a woman would remarry without a Jewish bill of divorce, without a get, even if she had a civil divorce, her marriage would be considered to be adulterous. Even for the husband, after Chayman Rabbeinu Gershom, it would be considered to be sinful. If a child would be born from a woman's second marriage after she got divorced from a Jewish husband without a get, then the child might have the stain of illegitimacy, which will prevent that child from marrying freely within the Jewish community, certainly the traditional Jewish community, when the child becomes older. And we're presented with a number of such cases, which are very difficult and very heartrending and very vexing in terms of trying to resolve. So you don't want to place anybody into that type of a situation where they would potentially give birth to illegitimate offspring afterwards. That's why the get is very, very important. And that's why it's so important to go in front of a skilled and recognized rabbinic court to do the get, to make sure, number one, that the get is done properly, and number two, that the get will be recognized all over the world. There are only certain rabbinic courts that are recognized as having the knowledge and proficiency and reputation to do a proper get. Very important that the parties go in front of such a bet-in so there not be any questions regarding the get afterwards. And we have to do our job to live up to that reputation, to do a very thorough job in terms of ensuring that there be a proper get that is given. One of the most important aspects of the get is writing down the names of the parties properly. The get document consists of no personal information about why the parties are getting divorced. It's a Hebrew document that's 12 lines. That's the numeric the value of the word get. Each letter in the Hebrew language has a numeric value. Get is Gimel and Tes. Gimel is 3 and Tes is 9. 3 plus 9 equals 12. So we commemorate that by having 12 lines on the get document. And the get document basically says, on this date, if it would be done today, it would say on the 8th day of Mar Cheshvan, here in the year 5782, here in Chicago, which is right next to this ocean that we call Lake Michigan. This man named such and such, and it's written in the first person as if he's writing it himself. So it says, I, the man named such and such, am hereby divorcing you, my wife, so and so, and you are free from me, and you are free and permissible to anybody. This is a document of divorce according to the laws of Moses in Israel. That's the whole thing. That's the whole thing. Very simple, legalistic document. It is distinguished in terms of its date, its location, and the names of the parties. Everyone's name is written in terms of their names, and in terms of usually the formula is the father's names. We didn't always have last names in our tradition, but we write, and last names sometimes can be confusing. What's really the person's last name? We write the father's name, assuming that both parents were born Jewish. If the father was not Jewish and only the mother was Jewish, so then we write the mother's name. If the person is a convert, so then we write that they're a convert, that they're the son or the daughter of Abraham Avinu, because Abraham was considered to be the father, the progenitor of all future converts. But it's very important to get down the name clearly. A person could have multiple names, and again, you have to write the person's Hebrew name, their English names, their nicknames. Sometimes people have very strange nicknames, unusual nicknames. Everything has to be transliterated into Hebrew, and there are rules as to how you transliterate names, and there are rules about which names to include and which names not to include, and there are rules about if a person once had a name, but they haven't used it in many years, so then it's not considered their name anymore for purposes of the get, and if you write it, the get might be invalid, so it requires a lot of training, a lot of expertise to know how to write the names properly. Sometimes I'll look at a get that was written outside of our circles by a betin that's not really recognized per se. And I see the mistakes made all the time with respect to the writing of names, where the betin just wasn't meticulous in terms of listening closely to the name. They get it wrong altogether. And a person's name is Mac, and they think they heard the name Mark, and they just write the wrong name, and that causes the get to be invalid. And the woman the wife, if she would remarry afterwards, it would be considered an adulterous relationship. So one has to be very, very careful. This is why we spend a lot of time with the parties. Often I will call them before they come into the bet and to go over their names, just to make sure that if there are any questions in this regard, it can be properly researched and clarified and resolved before we actually sit down to write the get. Then all of the writing materials of the get are presented to the husband, because technically, according to biblical law, he's supposed to write the get with his writing materials. So he makes an acquisition, he picks up the writing materials in front of the witnesses, so we know it now belongs to him. Then he appoints the scribe to write the get, and then he appoints the witnesses to sign the get. The scribe then writes the get. It has to be written specifically for the sake of the husband, for the sake of the wife, and for the sake of the divorce. If there were pre-printed forms, we can't use them because they weren't written specifically for the sake of this husband, this wife, and this divorce. So that's why the whole thing has to be written on the spot. It has to be written with special Hebrew calligraphy by a trained scribe. So all of this requires a very careful procedure. There are some rabbinical courts that charge up to $800 for a get, because the scribe and the witnesses have to be paid, and a lot of expertise goes into it. There's a certain amount of overhead in terms of the office scheduling and making sure that everything is done properly. We actually don't charge that much here at the Chicago Rabbinical Council, and one of the reasons is that we want to encourage parties as much as possible to do the get, because it's important for them. It's important for their lives. If we had the ability to charge nothing, then we could do that, except that the husband really is supposed to pay for it to show that this is his get, that he's acquiring the materials on some level in order to write the get and make sure that it's his own. Even when he appoints the scribe is really writing the get on his behalf. It's considered like the husband is writing the get through the scribe's hands. And then after the get is written and signed by the witnesses, under Jewish law, in order for a Jewish divorce to be effectuated, you need two witnesses to cause the act to be effectuated. Then we ask the questions of the wife. Are you accepting the get of your own free will? She says yes. And then the husband delivers the get into his wife's hands in the presence of the witnesses. We make sure that it's delivered properly. He makes a recitation at the time. He says, this is your get, your bill of divorce. You're hereby divorced from me and you're free and permissible to anyone. And he drops the get into her hands, and that effectuates the divorce. The get document itself afterwards is stored at the Beit Din. Important for people to know ahead of time in case the wife is planning to walk out with the actual get. The reason for that is that was an enactment made maybe 500 years ago or so, because, as I said, everything has to be written with great precision, even the letters of every single word. And what I translated to you to English, the Hebrew text, every letter has to be written perfectly. You can't have a break in the letter. You can't have one letter touch another letter. So there would be troublemakers who would sometimes try to get a hold of a get, and they would want to claim that the divorce didn't really take place and the wife's not really permitted to remarry. And they would look for problems in the get. Oh, this letter wasn't written properly. This word wasn't really written properly, and so forth. So in order to prevent the troublemakers from doing their thing, the rabbinical courts decided we're just going to keep the actual get document for safekeeping in the possession of the rabbinical courts. And what the parties receive is a tu'udat gerushin, a certificate of Jewish divorce. Certificate of Jewish divorce just affirms the fact that they received a divorce according to Jewish law, and they're free to remarry. And that's what we sign afterwards, and that's what we give to the parties. The practice of the Chicago Rabbinical Council is that we, generally speaking, will not deliver the certificate of Jewish divorce until the parties are also civilly divorced. It happens that as soon as the get is delivered into the wife's hands, she's considered to be divorced according to Jewish law. However, when we give the certificate could then be used by the parties to make an appointment with some rabbi to marry them to somebody else. And we don't want that to happen until legally they're permitted to marry somebody else. So to be on the safe side, so it doesn't look like we are endorsing the notion of parties getting remarried before they have their civil divorce, we usually hold on to the certificate until the civil divorce is completed, but the parties are divorced according to Jewish law even before the civil divorce. We sometimes get the question, should the parties wait until their civil divorce altogether before doing the Jewish divorce? So you don't have these questions or problems altogether. So the answer that I give is that's a bad idea. The Jewish divorce should be done as soon as possible once the parties know that there's no more any chance of marital reconciliation. They know that they're getting divorced and they're living separately. If they're living under the same roof, it doesn't help. You can't get a Jewish divorce if they're living under the same roof, because Jewish law presumes that if a couple was once married and then they're secluded together overnight, it's assumed that they got back together and then they consecrated a new marriage with each other. So therefore, they have to be separated. But as long as you have these two components, number one, there's no further chance of reconciliation. Number two, they're living in separate premises. It's appropriate to do the get as soon as possible. The reason for this is twofold. Number one, we're afraid if we don't do it now, maybe they'll forget afterwards. Right now, they're involved and they're engaged with the divorce process, especially if they're not so observant. It might not be foremost on their mind. So it's good to make sure that they take care of it. The second reason is because as the divorce goes on, it might get more acrimonious. And while they may be both very amenable at this moment in time in terms of doing the get, maybe later on, especially you have husbands who will use the get, as we mentioned, as a form of domestic abuse to torment their wives and say, oh, maybe I'm not going to give you the get after all, or maybe I'll use it as a bargaining chip. I'll use it as a weapon. I'll use it as leverage that I'm not going to give you the get unless you agree to joint custody, or you're not going to give you the get unless I get to keep the house. And they make it part of the negotiations. From the perspective of Jewish law, that's an abhorrent thing to do. The get does not give the husband any greater monetary rights or negotiating power from the perspective of Jewish law. The get is supposed to be something which is pro forma, that it's given when a marriage is over. Why did the Torah require that there be this thing known as get altogether? It's not our place to examine the reason for the various edicts of the Torah, but nonetheless, the commentators do give some sort of explanation. And one of the explanations is that the get is there in part to protect the women. Remember, I mentioned earlier about the ketubah, that you have the marriage contract that is intended to discourage a husband from divorcing his wife against her will because he has to pay a certain amount of money. Well, the get also is a whole big process. You have to find a scribe, you have to find 2 witnesses, you have to make sure there's a competent rabbinic court that's able to preside over the get. So the idea in part is that when the husband sees the severity of the matter and all the people have to be involved, if it's not absolutely necessary to terminate the marriage, he's not going to terminate the marriage so precipitously. It kind of creates a little bit of a buffer that it's not so easy to get out of marriage according to the Jewish tradition. But that same consideration as to why the get is there to stop a husband from divorcing his wife when she wants to stay in the marriage, and it could be a viable marriage, is precisely the reason why a get must be given as a matter of course when it's clear that the marriage is no longer functional, because the wife then has to be released so that she'll have the ability to be in another marriage which is functional. That's why the Talmudic, in the Talmudic canon of the tractates of the Talmud, the tractate that deals with the laws of divorce actually comes right before the tractate that deals with the laws of marriage, because divorce is considered not to be the end of the journey, but it's considered to be a segue towards the parties being able to enter into a better and healthier and more functional relationship. Now, when you have a husband who lives in New York and the wife's already in California, or it's uncomfortable for them to come together to the bet and all together, we can arrange for the husband to appoint an agent. All these parties, the scribe, the witnesses, the agent, are all provided by the bet-in. Husband just has to show up. He can appoint an agent, and that's also a part of the ceremony that we have, the appointment of an agent. And then that agent can deliver the get or appoint another agent in a different state or a different country. Sometimes one spouse is in Israel or in England or in France or Italy, and the bet-in over there can deliver the get, or vice versa. We deliver gittin when the husband's in Israel and the wife is over here, and so forth. All of that can be done. Now, what happens when you do have this type of situation where a husband is holding up a get? The wife can also hold up a get, but with the wife holding up the get, it doesn't happen as often. Maybe one of the reasons it doesn't happen as often is because of the fact that since it's only a rabbinic law that a husband can't marry more than one wife, there is a rabbinic escape hatch from the rabbinic law. The rabbis can't make an escape hatch from a biblical law, but from the rabbinic law, they can say, we'll allow a husband to marry a second wife if the first wife is behaving very, very badly. She's completely uncooperative and so forth. If 100 rabbis agree, he can marry a second wife. Sometimes there's a lot of abuse with respect to when that allowance is given, and it's given when it really shouldn't be given. We only provide that heter. It's called the heter mei rabbanim, the allowance of the 100 rabbis. We only provide that when it's a situation where the wife is unfortunately mentally incompetent. She is suffering from advanced dementia. And even then we do and she's not capable of receiving a get. But even then we do very extensive research to make sure that it's really true. We'll visit the wife, we'll speak to the doctors and make sure that this is the case and make sure that she's financially provided for. That's a Jewish law requirement as well. And that a get is provided so that if she should ever get better, which in our cases is not really a viable possibility, a get would be available for her unconditionally and immediately whenever she would want it. But there are rabbinical courts, even valid rabbinical courts, that will say if a wife is acting in a way which is sinister, that she is using the get herself as a weapon or as a form of leverage in order to extract concessions from the husband when it's not when it's not warranted, and she's refusing to accept the get, so they could give a heter permission for the man to marry somebody else, as long as he makes a get unconditionally available for his wife. So there is an escape hatch. Maybe that's why we don't have as many cases. It's not an easy escape hatch, and we don't provide that escape hatch in most cases, but it is available. Maybe that's why. They say in Israel, there are just as many cases of women refusing a get as there are cases of men refusing to give a get. That hasn't been my experience. My experience is 95% of the problematic cases are cases of husbands who are recalcitrant, who are refusing to give a get. So what do you do in those cases where husband is recalcitrant? Well, really, in an ideal world, we would bring him in front of the bet and would say, you have a right to make a claim according to Jewish law that this marriage can be saved, that you don't have to give the get right now, or maybe the get doesn't have to be given until certain things are resolved. You have the right to make that claim, but you have to come in front of the betin and make that claim. We have cases like that. The husband comes in front of the betin and we'll rule. You have to give a get today. You have to give a get 3 months from now. We never rule. You never have to give a get. Or that maybe the marriage should go through a little bit more of a testing period to see if it can be salvaged. If the case comes in front of us, we can determine based on consultation, obviously with experts from Shalva and elsewhere, what are the appropriate steps to take for this marriage. We can figure out a proper course. We would never deny a woman a get or anybody a get when a marriage is clearly over. But what happens sometimes, and we've had that, and we've issued decisions, and sometimes the husband says, you told me I have to give a get in 3 months. I disagree. My lawyer tells me I don't have to give a get till the civil divorce is over. That might be a year and a half from now. Goodbye, have a nice day. And we say, I'm sorry, you have to listen to the edict of the betin. What can the betin do to enforce its edicts? The betin can do things. The betin can, in most cases, order that the community take steps to make it clear that a man who's refusing to comply with the edict of the betin is not considered to be in good standing. That means that you can do what's called distancing measures. Halchokos to Rabbeinu Tam. There was a great authority named Rabbeinu Tam who said maybe around 900 years ago that you can enact distancing measures against a recalcitrant husband. You're not going to allow him to get called up to the Torah in synagogue. You won't have membership privileges. You won't be invited to bar mitzvahs or weddings. You won't do business with him and so forth. And he sees he's denied all of these communal privileges, so then he'll be more cooperative. There was legislation in New York where they tried to codify this idea of withholding privileges into legislation. That was the New York Get Law section, Domestic Relations Law, section 253, said if a man wanted a civil divorce from his wife, so he had to remove barriers to remarriage. In other words, give his wife a get if they were married in a Jewish ceremony in order to be entitled to the benefit of a civil divorce, because there it's not coercive, it's just we're withholding a benefit. So that was Rabbeinu Tam's special contribution to this area of law. So that's not considered to be coercive. It's coercive if you impose a burden on somebody, you take away money from them. You just say, I'm not going to give you money. I'm not going to give you a benefit. I'm not going to call you up to the Torah, invite you to my bar mitzvah. That's not considered to be coercive. So that get law was also not considered coercive. You want a civil divorce, where does it say in the Torah you're entitled to a civil divorce? You want the benefit of a civil divorce, you have to first give your wife a get. The rabbinic authorities were comfortable with that law. Then they came up with get law number 2 in New York, which is domestic relations law number 2, section 236, which says that when a judge is allocating the maintenance obligation of a husband or distributing the marital assets of the marriage, then the judge should take into account if one party is creating barriers to remarriage by refusing to give or to accept the get. That was more problematic, but because if you're saying that a person really is entitled to 50% of the assets, but now we're going to take away 50% from that person because they're not giving, unless they give a get. So that already has a coercive element to it. So many of the rabbinic authorities were not in approval. They were not in approval of get law section 236. And if a man walked in front of my betin in New York, when I was in New York, and would say, I'm only giving the get because of get law section 236, sometimes I wouldn't be able to do the get on that basis. Sometimes you could, but sometimes Jewish law permits a certain amount of coercion, even physical coercion. We obviously don't do that. But certainly financial coercion, if there would be a law that permitted it and said we're going to take away some of the assets from the husband unless he gives his wife a get. So that can be permitted if he's acting very, very badly. If there is if for example, the rabbinic law authorities talk about cases where the man was a serial adulterer who frequented prostitutes, or he beat his wife. You have cases of that sort, so then a certain amount of coercion could be ruled by the bet din. But if it's just a case of irreconcilable differences, the wife says, I just find my husband to be repugnant. So repugnant is a big deal, but it's not an objective standard per se. That's in the context of a subjective relationship between the parties. So then outright coercion is not permissible, but withholding of benefits is permissible. So it's a difficult balance to maintain. So really what we found to be the best resolution, there was an Illinois case that I put on the summary called In re Goldman, in which the Rabbi Schwartz, my blessed memory, Rabbi Gedaliah Dov Schwartz, my predecessor here at the Chicago Rabbinical Council, was called to testify in a case where a husband was refusing to give a get, and Rabbi Schwartz testified that the ketubah, which says that they will conduct their lives according to the laws of Moses in Israel, that requires that when there's an end of marriage, it has to be according to the laws of Moses in Israel. It's a contractual obligation the husband undertakes when they enter into the Jewish marriage contract to give a get in the event that there'll be a Jewish divorce. And the court accepted that testimony, but that's an unusual case, very unusual case. In fact, my sense is that the other jurisdictions have not really followed suit to say that they're going to actually enforce again on that basis. And even according to Jewish law, it would only have to be in a case where Jewish law absolutely mandated that you could utilize the courts to force a husband to give a get. In that case, my understanding is the husband still refused to give a get even after the court ruling, but he said to his wife supposedly afterwards that I'll give you a get under my dead body, and then he died two weeks later. So apparently, sometimes you have divine intervention when it comes to these matters, but that's always something that you can rely upon. What we really encourage very much is that the parties enter into a prenuptial agreement. We have a Jewish law prenuptial agreement that says two things. Number one, if there's ever a dispute regarding the get issue, they agree that they will submit that dispute in front of the bet din. And so the bet din has the jurisdiction and the authority under arbitration law to issue a binding decision. That's the case of Abitzur versus Abitzur, the New York case from a number of years ago. That I'll try to give the citation. I have it here, and it's in the materials in my article. The Abitzur case. It's 58 New York State 2nd 108 for 1983 case, famous case. The Abitzur case says that if the parties sign an arbitration agreement to arbitrate the issue of the get in front of a bet din, that's considered to be a neutral application of law principle that is not specifically religious in nature, just to arbitrate a dispute, even if the dispute is religious in nature, and therefore that can be an enforceable clause. So therefore, that's the first element of the prenuptial agreement. If there's a dispute about the get, they agree to come in front of the bet din, they will follow the ruling of the bet din. However, let's say the bet din rules, husband has to give a get. Still a little bit questionable about whether a court, at the end of the day, they might compel appearing before the rabbinic tribunal. Compelling a get after the bet din has ordered it, that might be compelling a religious act, a little iffy whether a court is actually going to do that. But a court will compel compliance with a monetary award given by the bet din. So the other aspect of the prenuptial agreement is that the husband agrees he's going to pay a certain amount of money every single day for as long as the couple is separated, as long as they're still married according to Jewish law. They'll say, oh, it's coercive. How could that be an enforceable provision according to Jewish law, even if the secular court authorities will recognize it? Why is that less of a problem than get law number 2, section 236 of the New York Domestic Relations Law? So the answer is yes, if it would be $1,000 a day, it would be a problem. But the way in which we calibrate the monetary amount of support is that it is tied in with the cost of living of the parties. we've calculated in most of the communities in which we operate, the cost of living, food, clothing, shelter is approximately $150 a day, $55,000 a year or so, without getting to child costs and things like that, which are not the person's cost of living per se. And therefore, that's the amount that the husband takes upon himself to pay every single day. And also, the other Jewish law requirement is that the document can't say that this amount is paid as a penalty for not giving a get. No, it's being given as support. The word get cannot even be mentioned. You look at the document, it just says it's going to be paid for as long as the parties are married according to Jewish law. Don't have to be a genius to figure out that if you don't want to be married according to Jewish law anymore, in order to not have this obligation over your head, you give your wife a get. Presto, you're no longer married according to Jewish law. But the word get is not explicitly mentioned. We have found in approximately 100% of the cases in which parties have signed this type of prenuptial agreement before they got married, if there was ever a divorce down the road, the get was given in a prompt fashion without these problems that sometimes linger on for years, sometimes linger on, unfortunately, for decades, where you have a husband who refuses to give his wife a get. Sometimes I have a couple where the husband's rabbinic authorities are not so comfortable with the prenuptial agreement. I think there's more and more of a consensus amongst the rabbinic authorities that it's a good thing. The late Rabbi Yosef and Razal Menachem Goldberg and the current great rabbinic authority of Rabbi Yona Reiss all endorse it, but there are some rabbis who are a little bit reticent. So then, even if you have just the one part, the first part of the agreement, if they agree to show up before the bet in, and you can compel arbitration over the issue before the bet in, even without the monetary obligation, that also accomplishes a lot. As one Jewish philosopher who shall remain unnamed once said that I think 90% of success in life is showing up. So 90% of success with respect to resolving these get issues is getting the husband to show up. I find that goes a long way towards resolving the issues. Another type of mechanism is when you're working as a lawyer and you have the parties sign a settlement agreement. So if the get has not yet been taken care of, you can put the get into the settlement agreement. But people mess this up all the time. What they do is they have a settlement agreement in which all aspects of the marriage are settled: distribution of assets, child support, marital, spousal support, parenting arrangements, et cetera, et cetera. And they just put in a provision that says 30 days after the divorce, within 30 days after the divorce, the parties agree to comply with respect to a get, to show up in front of the Chicago Rabbinical Council, whatever it is. They'll split the costs, or the husband will pay the cost, or the wife will pay the cost, and that's the provision. Very difficult to enforce. Once the divorce goes into effect and the whole settlement agreement goes into effect, what's going to happen if the husband doesn't abide by this provision? If you're going to beat him up in court, that might result in a coerced get. That might, if the conditions are not such to allow for that type of court intervention, you don't have a Rabbi Schwartz making that determination. So it might result in a coerced get, and a court might not want to get involved altogether. What happens is after the divorce, it's often out of sight, out of mind. You don't have the same connection with the party and with the party's lawyer, with the lawyers negotiating with each other anymore. They're on to their next case. Very difficult to enforce. So we have a form of the settlement provision that says that the divorce shall be given by the parties within a certain amount of time. But it also has the following sentence: both parties hereby agree and consent that the other terms of this agreement shall not become final before the get has been obtained. In other words, none of the agreement goes into effect until the get has been completed. This way, the parties know that it's all part of one integrated package, and nothing gets off the ground until the get is given. That's the language that I very much endorse and support, and that goes a very long way towards preventing these problems of having a clause which really has no weight and no teeth for the future at the end of the divorce process. The best thing is to make sure that the parties show up in front of the bet and do the get before the settlement agreement is signed altogether. But if for whatever reason you can't have that, so then this is the way that it should be incorporated into the agreement, and you should specify the name of the bet-din, whether Chicago Rabbinical Council or Rabbi First of the Agunah, some sort of a bet-din that is internationally recognized, so that you know that the party's not going to pull any shenanigans and find some unauthorized person to hand them a document and say that this is a get and that they have complied with the terms of the agreement, and then be stuck without a meaningful divorce that would be recognized worldwide by Jewish law authorities. Sometimes we have the parties come in front of the Beit Din and say that they want the Beit Din to resolve all of the issues. You have sometimes a husband that reacts to a summons. The wife sends a summons that she wants to get. We'll send out a summons. If the husband doesn't comply, let's say we don't have a prenuptial agreement, we have the ability to issue an order of recalcitrance called the shtar seiruf against the husband. That means something if the husband cares about his good standing in the community. Often he does, and it goes a long way. You have organizations such as ORA that will stage protests and demonstrations in front of the husband's house if he's subject to a shtar seiruf, to a contempt order. But sometimes you have a husband who's so far removed from the community, he doesn't care anymore about a contempt order. So the best thing, that's why I said, is to have, the prenuptial agreement, but a contempt order can go a long way in terms of at least putting communal pressure upon the husband. And certainly that's something that we issue. One time I issued a shtar seiruf, an order of recalcitrance against the husband for not showing up in front of Beit Din or giving his wife a get. Really, all he has to do is show up, present his arguments, then we could decide whether he's right or he's wrong, but he wouldn't even show up. So he sued me for $4 million. $4 million, he sued me. He claimed that I left a message on his answering machine threatening to break his legs. I appreciate the compliment, didn't do it. The case went away, but we stood our ground, and thank God the man eventually submitted to the jurisdiction of a different Beit Din. That Beit Din ordered him to give his wife a get, and he gave his wife a get. You have to sometimes have a very strong backbone in this business, because you're dealing with people who can be very contentious and confrontational. That's the way it is. But our job is to preserve the sanctity of the Jewish marriage and the Jewish divorce process, and to make sure that nobody is going to be trapped as a hostage in a marriage that is functionally over. We have to make sure that a get is given when proper. So sometimes the husband will say, "I'll give a get, but I want everything resolved, not just the get issue. I want everything resolved. I want the spousal support to be resolved by the Beit Din, child support. I want a Jewish law process. I want division of assets to be decided by the Beit Din." Nothing wrong with that. You can have the Beit Din resolve all issues. In fact, according to Jewish law, if a divorce matter is going to be litigated, according to Jewish law, the parties are supposed to litigate in front of a Beit Din and not in front of a civil court. Obviously, we have a job to do. We have to make sure that we are familiar with the laws of child support as a public policy matter. We have to, any child support ruling has to comply with the Child Support Standards Act of the state of Illinois. So we have to be cognizant of these things, and we have to ask for the lawyers to submit their arguments. And when dealing with child custody and parenting arrangements, technically speaking, our decision will not be enforceable if either party wanted to walk away from it based on the parens patriae principle that only the courts can decide what's best for the children. But if the Beis Din works with the parties and the lawyers in what I call a collaborative arbitration, where the lawyers trust the Beit Din process, they see that we're dealing that we're working together with top therapists in terms of helping to determine what the parenting arrangement should be and so forth, or just as qualified, or the same people who would be advising them in court, and they see that we're very meticulous about the process. So there's an agreement, a collaborative agreement, that the lawyers will incorporate the decision of the Beit Din at the end of the day into a marital settlement agreement. And once the parties sign that marital settlement agreement, so then that becomes a binding upon the parties, unless there's something that would, shock the conscience, clearly not be in the best interest of the children and so forth. But otherwise, that's considered to be binding. We do that all the time. I have to tell you, we do that all the time. It's one of the benefits for me, I guess, of my combination of rabbinic training and legal training, that I've learned how to combine both elements of Jewish law and civil law in terms of fashioning a decision which encompasses all of the considerations of a civil law, while still being what I consider a sacred Jewish law process. And of course, we make sure that the get is given in the course of that proceeding. Now, the last thing that I will mention, and I want to leave 10 minutes or so for questions, because I'm sure that you have questions, is that I don't understand. And I say this not only as a rabbi, I say this as a lawyer, I say this as a person who has dealt with Jewish divorce matters for close to 25 years. And I've seen all the problems from both sides and all the shenanigans and the fact that sometimes there are valid complaints that husbands have against wives, that wives have against husbands and so forth. I don't understand how a lawyer how an attorney can support a party in terms of withholding a get. I don't understand that at all. A get is not a part of the American legal system per se to say that this is one of the cards that you have on the table that you can use. Whatever is fair and right in terms of the equities of the case that have to do with the finances, the division of assets, so that can be decided looking at the assets and looking at the entire picture of how various assets were acquired and so forth. Whatever has to be decided in terms of child support, in terms of child custody. So you look at the best interests of the children, nothing whatsoever to do with the get. It has to do with just an assessment of parenting skills, styles, what the children's upbringing, the needs of the children and so forth. What justification is there to hold up the get and to try to extract concessions from the other party because of the fact that the get is going to be held up? It's, I believe, something which is in the realm of a cruel and unusual punishment. It's just not something which is conscionable on any level to support somebody to threaten to hold the other spouse hostage forever. Where do you find that in the American legal system where a divorce could be upheld? Eventually a divorce, once the other issues are resolved, the divorce is going to be handed down at some point. The notion that you're saying the divorce will be handed down, but the person will not be allowed to get remarried because your client is going to withhold the get, I consider that to be a breach of ethical duty. I don't know if anybody could be summoned for disciplinary action based on rules of professional responsibility on this basis, but in my opinion, that you should be able to do that because I consider that to be highly unethical for any single attorney. I'll always say whenever parties come to me, for example, for purposes of a mediation, so I'll say that I always will consider each party's position as legitimately within the realm of discussion. But I say this is not a position that I'm taking in favor of one party or against another party, but I'm in favor of the get being given. Whatever the positions of the parties might be, in this case, one party wants it, the other party doesn't want it. I'm not ruling on behalf of that party. I'm ruling on behalf of Jewish law. Jewish law says the marriage is over, a get should be given. I just want to make that point. I feel very, very strongly about this. I don't understand how anybody could take a different view. You say, oh, I have to zealously represent my client. You have to zealously represent ethical behavior as well. The Rambam has this notion, Maimonides says sometimes Jewish law permits actual coercing the husband into giving a get, actually even allowing physical coercion, not something that we do nowadays. He says, how could the get be valid? According to biblical law, it has to be of the free will of the husband. He says that sometimes a person's behavior is just so egregious that when we're beating them up, we're not beating up the person. We assume that the person deep down is a good person. We're beating up their evil inclination. Sometimes you have to beat up the evil inclination of your client as well, and not support these types of shenanigans, and certainly not introduce this notion if you're the attorney. Oh, you have the chance of holding up the get and getting something out of it. I consider that to be unconscionable. Okay, good. I've said my piece, and now we have a few minutes if anybody has any questions.
Thank you so much. I love how passionate you are about the ethical obligation. And I've been typing things into the chat, some nuggets that you've taken, that I've taken away. And I have heard you speak before, and every time I learn something new. So thank you so much for that. We do have a few questions to get through. Some of them will be quick, I think. The first, thank you, Christy. Does the CRC only help couples with the get process if they are a certain denomination? If they were married in any civil ceremony or religious ceremony, does that really matter? And how much does the Midwest Faith Bend charge?
How much does the Midwest Faith?
How much do you charge for a get?
Oh, okay.
Do you care what denomination of Judaism a person is?
We don't care what denomination of Judaism a person is. We do get them for all denominations. Doesn't matter if a person is Orthodox, Conservative, Reform, Reconstructionist, Humanistic, or non-affiliated altogether, or any denomination that I may have missed. As long as the couple is Jewish, a get should be given. And we're more than happy to take care of the get. We take care of the get for all denominations. Even if people, let's say they're converts and they're non-Orthodox converts, doesn't matter. We do get and we do Jewish divorces for everybody. Because we really view ourselves as the rabbinical court for the entirety of the Jewish community. As far as what it costs, you should know, I never get involved with that because my job is the chief rabbinical judge, Rabbi Abramson. But thank God, a wonderful administrator of the Betin, so he gets involved with the finances. My understanding is that it's something like $350. I might be up by $25 or something like that. Really not a very hefty sum. If it's done through an agent, maybe it costs a little bit more because then it becomes two different processes. So you need the husband to come in one time, and then the wife to come in the next time, and you have to work with another betin. So it's a longer process. It might cost a little bit extra, but we never refuse to do a get for financial reasons. If a person can't afford it, so we make arrangements and we make accommodations and we subsidize the get so that nobody should be deprived of the ability of receiving a get.
Great. Okay, next question. And I'm just going to read this because I'm not sure I completely understand it. If there are no ways to enact a get, can the Beit Din use the Safek Kiddushin? Was the original marriage valid per halakha as a way of releasing the woman? Oh, so I guess the question is, if you can't give a get, is there a way to say that the original marriage was not valid?
Sometimes, but it's really, really hard. I have to tell you, because whenever you're going to make a determination that there wasn't really a halakhically valid marriage, a marriage that was valid according to Jewish law, and therefore a get would not be required, it requires enormous amount of research. You should know we don't charge for this research, but we have to expend an enormous amount of energy. We look at wedding pictures, we look at videos, we look at invitation lists. We have to, find out every single aspect of who was at the wedding and whether every single person who was there was disqualified from being a kosher witness for one reason or another. If there were witnesses who were designated, we have to investigate what was the nature of their Shabbos observance, of their kashrus observance, to see whether there's some way to claim that they weren't a valid witness. And maybe even if they weren't valid, maybe somebody else who was like a distant relative who's not disqualified based on their relationship, was a second cousin once removed, who's an Orthodox Jew, was there and was an observant to somebody who was a Sabbath observant, and they really could have been a valid witness, and they could count as a valid witness, and maybe the rabbi himself, even if he was from a different denomination, was himself scrupulous about halakhic observance, so he really was a kosher witness. So it's not a slam dunk. So yes, when we have to do that because we're just getting zero cooperation from the husband and we can't find the husband or whatever it is, we will engage in that investigation. It could take a really long time until we come to our conclusion, because we have to be very rigorous about the process. We're talking about the possibility of allowing, an adulterous relationship, God forbid. So we have to be extremely, extremely careful about that investigation. We'll do it when it's warranted, but I would not rely upon that in the first instance.
Great question. Okay, another question, kind of similar, and there's no such thing as ignorance. Well, you have to ask a question, right? If a Jewish couple weds only, say, before a judge, does the get still come into play if they later choose to divorce? I
didn't understand the question. What are they doing?
So if someone is married, if a Jewish couple chooses not to be married by a rabbi, but is married by a judge, can they still get a get on the back end?
So yes, they can and they should get a get in the back end, because even if the marriage wasn't consecrated by a rabbi, whenever a Jewish couple lives together, according to many authorities, just the mere fact that they're living together and the Jewish community knows that they're living together, that creates testimony that they entered into a marital relationship when we require a get. Again, push comes to shove, there might be room to be lenient in some of the difficult cases, but certainly in the first instance, you should obtain a get.
Okay. Next question. In civil law, if a party refuses to provide a deed to a house required by the MSA, the judge can sign the deed over to the spouse if it's required. Can a rabbi, oh no, can a rabbi sign or give a get in the same way on behalf of a recalcitrant spouse? No.
No, the answer is no. The answer is the husband must give the get himself. He has to do it himself. He can himself appoint an agent, to give the get, but he has to appoint the scribe to write the get. He has to appoint the witnesses to sign the get. If he doesn't want to deliver the get himself, he can appoint an agent to deliver it on his behalf. But we can't just impute an agency to the husband. It has to come from the husband.
That's what makes it so sticky, Charlene, and that's why it becomes a tool for spiritual abuse. Okay. With the collaborative process, are lawyers involved? So if you're working on an MSA with parties, or you're working out the terms of a divorce, do you do that with attorneys in the room sometimes?
Yeah, sure, 100%. And the attorneys are very helpful. I've had cases where I've asked the attorneys, like even when it comes to making child support calculations, when there are children in the picture, to submit, their own calculation, because it's kind of a complicated formula. Here in Illinois, it's only gotten more complicated. This way, I'm able to assess the different submissions given by the attorneys, and I can pull them together to help to explain any discrepancies and figure out what the correct formula should be. The lawyers are enormously helpful, I have to say, but lawyers get a bad rap, but for the most part, they're enormously helpful.
We are. Okay. What is the rabbi's take on I don't know this case, so I'm curious. Zebulon Simontov case. Are you familiar with that?
I'm not sure. Please just help me out. If somebody can help me.
I don't know what it is. Kenneth, I'm going to actually unmute you here so you can ask the question. Oh gosh, here you can. Kenneth A. Henry, is that you? Kenneth, are you still there?
Yep, still here.
Okay, what was the case that you're
referring to? Simontov was the last Jew of Afghanistan who
refused
to apply the get for 20 years.
Yeah.
Curious as to what your take might be on that case.
I didn't remember his name. Thank you.
I read about this. I'm glad that he gave the get. If they would have had him sign a prenuptial agreement beforehand, so maybe he would have given the get a lot sooner. I had a husband once who ran off somewhere to the Netherlands, and he tried to escape giving a get to his wife, and the wife was able to get him in front of the court in the Netherlands because he had signed the prenuptial agreement. And the judge over there said, you signed this agreement in America. You think just because you run off to the Netherlands, you can escape your obligations? You have to go to the Bet Din in America and take care of the get. So it was very helpful. So even a Jew in Afghanistan, might not be able to escape the clutches of the prenuptial agreement. But I'm glad the get was finally taken care of.
Great. Okay, we do have a couple more questions. If everybody doesn't mind, I understand that, we said it would only be an hour. So if you need to get off, I'm actually going to put the information for the survey into the chat. So if people can do that, that would be great. While the rabbi's answering the next question, which I'm just going to again read to you. You object to a husband and his attorney from immediately consenting to giving a get, but I don't believe you address the issue of shalom bias, which could legitimately be asserted by the husband in a good faith attempt to salvage the marriage.
Absolutely. Shalom bias is always a good thing. If there's a possibility of salvaging the marriage, so that's something that can be investigated. Of course, if after all efforts, the wife says, no way, no how, it's just not going to work. So at a certain point, you have to give up. You have to recognize when it's really over. It's not nice, as Maimonides says, women are not prisoners of war, that that the husband has the right to just beat them up with a club and drag them by their hair. And insist that they stay with them against their will. But yeah, if the marriage can be saved, so we're all in favor of saving viable marriages. We're talking about when the couple is clearly getting a divorce, and the get is just being used as a weapon.
Okay, and another question, can Rabbi Reese clarify that intermarriages do not require a get, assuming that there is no conversion? So if both parties are not Jewish, do you still get a get?
No, if the parties are not Jewish, or even if one party is not Jewish, no get is necessary.
Okay. I think that is all the questions. I'm gonna, if I didn't get your question, if you could re-put it, oh my gosh, if you could write it up again in the chat, that would be great, because I think we've gotten to the end, but I just want to make sure. So I'm going to watch this for a second. Looks like maybe one more question came in on the Q&A. Nope, we got that one. And with that, I just want to thank Rabbi Reese and everyone here for your great questions, for your wisdom, Rabbi. It's been a fascinating program. It's something that people have asked for from Shalva and from the legal committee to have this kind of information available. We will also have it available as, you won't be able to get CLE, but we will put the recording up on our website so people can watch it later. Please let your friends know about it. We do have a text to give function right now. If you want to text HOPE to 345-345 and make a small donation for today, that would be wonderful. And please don't forget to do the survey so we can continue to give you good programming. And with that, do you have any last words, Rabbi?
Just that I wish everybody that you should only have loving and harmonious relationships in your own lives.
Thank you very much.
All the best.